723 was witnessed 9/11, with any year a guess. My signature appears on as the seller with the date of October 11, 1990, a month later. President Gary Watkin, then, of the Three Banks in One did respond to the original complaint filed in April of 1992 to the Controller of Currency. The President responded to the original complaint as required by the Controller of Currency states below. Paragraph 5. Mr. Clay was indebted on the first mortgage. He therefore had no liability or concern of judgments because of Mrs. Clay's encumbrance of the property after his quitclaim deed to her in 1987. The bank made a decision to sell the property for $73,000, notwithstanding our appraisal price of $84,500, considering that the real estate market was very soft and that the bank would have to pay approximately $5,000 in realtor fees. The best case scenario is a net sale of $76,000. This figure is derived from a formula of presuming that the normal sale price of a home is 96% of the list price. Therefore, the sale price would have been $81,120 minus $4,900 in realtor's fees for a net sale of $76,220. Paul Wilson told Mrs. Clay on several occasions that the bank would be more than willing to forgive several $1,000s of her indebtedness because of her concern at the amount of the sale price. Forgiveness wasn't what my complaint concerned. It concerned consumer fraud, as noted by defective deeds filed by public officials and placed knowingly in the public file as reliable information. Below is a very interesting statement made by President Watkins of the Three Banks in One. He states, Mr. Clay, their buyer, was only indebted on the first mortgage. He therefore had no liability or concern of judgments because of Mrs. Clay's encumbrance of the property after his quitclaim deed in 1987. President Watkins' response as above was his answer to the question below that was asked to the Controller of Currency. In paragraph 5, Ernest Clay said, at the time, my asking price was much too high, that he was aware of the fact that the bank had asked for the deed in foreclosure and that his relationship with First of America, with the President of First of America was such that he could get a much better deal, and did. The original complaint concludes, in conclusion, it is the bank's position that we have clear documentation to the facts that Mrs. Clay voluntarily deeded the property to the bank and that the property was sold at a reasonable amount. The bank does want to be repaid for any sums now owed by Mrs. Clay, and as our past record indicates, we will attempt to work out a fair solution with Mrs. Clay. It is our hope that we have answered Mrs. Clay's allegations completely as your office deems necessary. We are anxious to resolve this matter and will await your response. Sincerely, Gary Watkins, President, Enclosures, April 10, 1992. That any clear documentation would be an order of the court. I have not been notified of any legal action, and I am unaware of the existence of any order of the court regarding my property from the state of Illinois, except for the court-ordered quitclaim deed referred by President Watkins in his above statements, quitclaim by his buyer to me in 1987 by an order of the court, was familiar to President Watkins by his own statement. How could a fair solution be worked out in 1992 when the property was sold to an individual person in 1991 and that individual person sold to another individual person in 2000? How can a note become separated from its collateral And how can an agreement be sold out of state when the agreement itself, when in the agreement itself it is stated in paragraph 12 and 8, it was agreed. Quote, governing law severability. This agreement shall except to the extent governed by applicable federal law, be governed by the laws of the state of Illinois. Invalidity of any term or condition of this agreement shall not affect the invalidity of any other term or condition. Perhaps a fair solution might be to have federal laws examined for violations between the three banks in one doing business in the state of Illinois and U.S. equities doing business in the state of New York. The Consumer Fraud Division of the Attorney General of the state of Illinois was mailed over 1,000 pages of prima facie evidence. Presumably, that evidence has been placed in consciousness as per statute. In taking jurisdiction of these records, Lisa Madigan states further, quote, if the dispute is private in nature and does not lend itself to mediation, we will suggest you pursue the matter through private counsel or small claims court. However, in most instances, our staff member will attempt to mediate this dispute by contacting the business involved, explaining the nature of your complaint, and exploring a possible resolution. End quote. A resolution is not what was requested. It was the solution within your power of authority to render that would fall within the realms of your job description. Anything more or less would be overstepping your boundaries. Specifically speaking, what kind of mediation is the Attorney General referring to? I'm afraid anything that might compromise my character would not be possible for me, as well as any resolution seeking to break or interfere with the law could never be considered by me. The private dispute I may have had with the three banks in one is that of breach of contract. However, since there's no contract signed to breach, leaving my civil liberties exposed for abuse, the power of justice has been obstructed and denied. The problem not understood is that the three banks in one regarding the sale of the real estate in question has no sale contract from me and no court order for a judgment from the court. In absence of a contract, there could be no breach of contract. And no contract, no argument. No argument, no civil case. But I'm still being denied access to my home, and the civil court is still powerless in hearing my case, while the Attorney General keeps repeating the same words, and to my annoyance, of hire a private attorney. Lisa Madigan suggested that that this might be a case for small claims court. But I am convinced that this is a case of national concern. The note sold to U.S. equities in New York was processed in the civil court of the city of New York with a judgment rendered in favor of U.S. equities. That this judgment was issued with lack of due process of the law and lack of jurisdiction over an issue with severability only in Illinois law, under Illinois law, or wherever federal law does not apply. On January 11, 2007, I appeared in the civil court of the city of New York after filing on December 26, 2006, a rule to show cause. An order to show cause was issued, and notice serviced upon U.S. equities ordering U.S. equities to show cause why that court should have issued them a judgment which violated my right to face my accuser, and this obstructed my right to be heard, and thereby denying me equal protection of the laws of the state of New York. On the return date of 1/11/07, U.S. Equities appeared and entered the note securing the property located in Champaign, Illinois. Presented and accepted in the New York State County Court was this home equity loan agreement on property located in the state of Illinois for litigation of a debt payable to U.S. Equities of $18,000 as noted by the judgment of the court and my credit report. That was a tragic and pitiful moment for me, and the ramifications are sustained. But what was even more tragic than pitiful was seeing the judges singing in the same choir and on the same stage, the same tune as all of the rest of the lawyers. Surprised and bewildered, I explained to the judge that the note presented before him was the note securing property located in the state of Illinois, and that property was sold more than 17 years ago, and again 6 years ago. The month and the year this judgment was signed by the Civil Court of the City of New York. But in retrospect, such a presentation in open court that had fraud as a face became an unexcusable negligence. After being heard by 6 judges officiating in the state of New York on this state of Illinois instrument, with the public looking on, became an obstruction I was not prepared to deal with. Therefore, I requested a trial by jury and paid the required fee for the privilege of assembling a jury panel of 6. And that has been obstructed. In Lisa Madigan's consciousness report, she writes, where evidence indicates that a business is engaging in substantial and or systematic violations of consumer protection laws, we do